Our topic today is, what do we do with those other people that want to come to our mediation room and disturb our process or support our clients? So let's have a look at some of the ways we can manage that. Before I go any further, I'd like to acknowledge Aboriginal and Torres Strait Islander peoples as the traditional custodians of Australia and recognise their continued connection to the land, the waters and the culture, and pay my respects to elders past, present and to emerging leaders. And I come to you today from the lands of the Gunai people in Gippsland in Victoria. For anyone that doesn't know me, I'm Joanne Law, Director of Mediation Institute. I'm a family dispute resolution practitioner and an accredited mediator. We're all accredited mediators AMGRAS now. And I also do complaint handling for mediators, family dispute resolution practitioners and family group conference facilitators. Some of the things are issues that may come up with complaints and things like that. Others relate to our standards and obligations, and today's session is for anyone who's a mediator, FDRPs and nationally accredited mediators. Please make use of the chat, introduce yourselves, who you are, where you are, and if you've got any specific questions about today's topic. And as always, feel free to join in the conversation as we go, either interrupt or put your hand up if you'd like to go a little bit deeper into something that we're talking about. So please make the most use of the opportunity to share and to learn. So what I thought might be a good agenda for today, why include others? What are the reasons we might have other people who are not parties coming to our mediation? The types of non-party support, when's it needed? Establishing your role and authority in the room. Some points on during the mediation, when the agreement's reached, and for family dispute resolution practitioners, certificate of dispute resolution and recap. But as I say, there may be other things that you want to get out of here. So please feel free to make use of questions or comments. So the main reasons why we'd include other people in the mediation is to assist the mediation process, particularly when there are major differences in participants' power, understanding, or some other factor. We have an obligation as mediators, whatever form of mediation we facilitate, to make sure that it's a fair process and that people have the ability to make informed decisions. So sometimes we need to bring other people into the process for that to occur. It might be to help to support or improve the sense of safety for a vulnerable person who, without that, may not be able to negotiate effectively. It may be because the parties want their lawyers there, so it might be very much driven by the parties or even by lawyers that are referring through to you. Or it might be because it's expected in the context that you're working. So if you're working in a court-ordered mediation context aligned with a court, generally the lawyers are going to be part of the process, sometimes even barristers and others as well. It very much depends on the context. With non-party support, it's not always just lawyers. It might be others as well. And I was thinking about it, how do we kind of structure? So it might be because they want them, and that would be a support person perhaps in a workplace mediation, for example, or because someone wants their lawyer. It may be that they need them. So psychological or other sort of support, it may be needed for an advisory role or communication. And I'm thinking particularly about interpreters. So they may be needed for the mediation to occur if English is a second or fifth language for someone. And it might be expected, as I mentioned, in the context where it's expected that lawyers or potentially other advisors might be involved. Generally, when someone just wants someone to come in, we treat them as an observer. So generally they're going to listen, but they wouldn't speak. They're not a party to the mediation. Some of the considerations we need to think about are one or both going to have this additional person, because it's going to affect the balance of power. Someone's got support people and the other one doesn't. I'm personally, I would be extremely reluctant to have one person in a joint mediation with support people behind them and the other one without. If that was what was being asked. We'd have a big conversation about that. I'd have to make sure that there's very informed consent for that to proceed. And usually in that conversation, people decide, in my experience, that they don't want to participate in that way. It may be we decide to go to a shuttle process so that they're not in the room together, and that's a bit different. It's very important when they want someone else to come in that we're very clear about their role. So it might be a phone call before, might be handing out information. Definitely would be getting them to sign the agreement to mediate regarding confidentiality. And we'd also mention at the start of the mediation. So, all the way through, we're making sure that people are aware of what their role and what's expected of them. The challenges you might have, and I guess why we're wanting to see who these people are. Are they thinking that they're going to go there as an advocate? So it might be a union rep or another advocate in a workplace mediation that really are not intending to be engaging in the process in an appropriate way. It might be someone really emotionally invested in the dispute. I had that once. I didn't screen properly. It was someone's mother who lived far away, and I thought it was going to be okay. But she was much more emotionally invested than anyone else. And in the end, I had to ask her to leave the mediation. In family dispute resolution, it's often new partners that someone wants to bring, but that's going to have potentially a really negative effect on the dynamic. And it's something that you might only want to do if the other person's really comfortable with that. Sometimes they may find that the new partner is more reasonable than the former partner, and they see them as a mitigating influence. It may be that they've got the major engagement with the children, for example, and so it's relevant for them to be there. I guess what I'm saying is we really need to consider the situation for the specific case that we're working on. And we certainly don't want people there who don't or won't understand their role. Any thoughts or comments about that? Yeah, Verity?
Yeah, just one. When you have support persons, and it can be a real issue for the other side, are there scenarios where they become a hidden support person by phone? How do you handle all of that?
Yeah, look, that's a great concept to bring up. And that's generally, so if, for example, someone wants someone, it's going to be a joint session, the other person doesn't, then I would generally be talking about phone a friend and having them available, that they can take a break and confer with them. That might be the case that they do with lawyers as well, if they don't want them there or need them there the whole time.
Yeah, and there's an issue of confidentiality as well that one has to be very much aware of.
Yeah, and look, it is a challenge, particularly for those of us that are doing online mediation, because we really can't control who's there. It can be the situation that there are other people who are present without us being aware. And different mediators deal with that in different ways. I've heard of some that have asked people to get up and do a 360 with their computer camera to know whether others are there. I don't take it to that extreme. Generally, it's asking if they're in a confidential, a quiet place where others won't overhear. Ultimately, I guess we're thinking of what are they affecting the dynamic? Is it going to be helpful for the other person to hear firsthand what's going on so that they're able to assist? I have heard of some mediators that do have that imbalanced room where one person has the support or advisors and others don't. I think we do need to be very careful that we are making sure that we're complying with our obligation to maintain a fair process. Sometimes that structure, it's very difficult to see how that could be fair, particularly if it's against the wishes of a party. You may find yourself getting challenges with a complaint in that sort of situation. So what about when they need others? It may be that we're reluctant to proceed without the person having additional support. And in that sort of situation where they're there for emotional support, again, they may listen but not speak. Or it depends on the context. They may have a more active role. It may be an elder mediation where someone's supporting a person who has some difficulties or an NDIS or something like that. It's not necessarily a blanket rule that the support people are not able to speak, but if they are going to be speaking as part of the mediation, why and what's their purpose and what's the scope of the role and what are they going to be doing? Generally in mediation, the support person isn't representing their client unless we're really up at that end of the settlement conference end of the spectrum where people are legally represented and the lawyers are doing the majority of the speaking. Do we need to use shuttle? So separate rooms certainly allow a lot more conversation between the party and their support or their advisors. Or again, are we going to need to do that to balance out the room so that one person can have support and the other not? And of course, if we've got someone who's there to help with language, ideally we're going to be wanting to use a professional who knows what their job is and doesn't have a conflict of interest. And you may not necessarily be able to assume there's no conflict of interest if it's a very specialist language or dialect, because the whole community may know each other. There may need to be some conversations around confidentiality more than you would normally expect. And if the person who's going to translate is a family member, then it's going to be really important to get everyone's agreement and make sure that role is well established. That might be a good point to pause as well. I don't know if anyone's got experiences with challenges related with interpreters as part of the process, or perhaps working with someone who's deaf or has some other impairment that they might need some assistance with. So all of those situations, we've got to really navigate, coming back to our principles of what's going to be fair, how do we maintain an even-handed process. I guess the point about negotiating, what's your approach going to be with regards to permissions for people to participate? Generally, my approach is that everyone needs to agree with the support people that are going to be there. And if someone doesn't agree, then I would go to a shuttle approach. I wouldn't generally indicate that the person's not allowed to attend unless there was a very good reason, and I can't think of the reason that would be. Yes, I guess that it's always a negotiation, but we need to remember that it's our room and we have the ultimate say about what the composition of the mediation is going to be. With family dispute resolution, Regulation 25, we've got an obligation to make sure that people are able to negotiate freely in a dispute that affects them. With lawyers present, you may be able to facilitate a process that you'd have to deem not appropriate if they weren't. And if one person only had a lawyer present, it's going to be very difficult for that to be a fair process. And then if we look at AMDRAS and the Code of Ethics, and hopefully everybody's had a good old look at the new AMDRAS standards, because they now apply to you if you're a nationally accredited mediator. And in the Code of Ethics, a couple of the really relevant ones are that we need to facilitate an even-handed, safe and ethical process, including point 3.1, protecting against misuse or abuse of power. So that power we're often thinking about the power between the parties, but we could be introducing a situation where there could be an abuse of power through the support people or the management of the support people that we allow into the room. And also point 6 in the Code of Ethics around advice, providing information, guidance, advice only when competent and authorised to do, and specifically only when possessing the requisite level of knowledge, skill or expertise, you're authorised by the parties, authorised by the relevant service provider or dispute resolution context that you're working in, authorised under your level of accreditation. So that's provisioning for specialist categories of dispute resolution practitioners, and holding the relevant professional indemnity insurance. The standard mediation insurance doesn't protect you for providing advice, because in facility of mediation we don't provide advice. If you think that advice is needed and you either don't have the current expertise, or you don't think it's ethically or safe for you to provide that advice as a mediator, which I would think is a good approach, then bringing in experts may be needed. So it could be a single expert, not a witness, but an advisor in particular, knowledge is spelt quite interestingly there. It could be ensuring that the lawyers are there to assist, particularly where after your intake you realise that there's some factual elements that are in dispute, and having advisors may be of assistance. I might just pause there before I go on to specifically. It's generally the lawyers involved in the mediation that I get calls, issues, complaints about. So I have dedicated a fair bit of today to talking about that. But is there anything of what I've raised already that people have got questions, comments, thoughts? So all very obvious and clear. Excellent. One of our other obligations as dispute resolution professionals is for us to be collegiate with our colleagues and others. And however, there can be, I know that some services just have a blanket ban. They don't allow lawyers to be present. Others, you're always mediating with lawyers present. So there's a real range and spectrum. I know some of the people here are lawyers, and you've probably been in both roles as the lawyer advocate or as the mediator facilitating. But I guess there's some pros and cons that we can look at. And part of what I'm hoping we can talk about today is how do we make sure that there's more pros in the process. So having the lawyers there can assist in breaking deadlocks, particularly caused by misunderstanding or misinterpreting or deliberately not wanting to believe in their legal advice. And certainly I've had situations in family dispute resolution, particularly property mediation, where I'm not willing to provide another mediation session without lawyers when we've got that sort of a situation. It's hard to deal with advice from someone who's not in the room if I'm pretty confident that there's some misinterpretation going on. Because, of course, I'm not a lawyer, and even if I was, I wouldn't be providing specific legal advice as a mediator. Sometimes we get clients that take a principled position without any real solid legal standing for their position. So having the lawyers there able to discuss that, and in that sort of situation, I'd be inviting the lawyers to speak about that situation, and certainly speaking a lot more in the private sessions or breakout rooms with their client about that. They can reassure clients that it's okay to commit to an agreement that's reached. So often people, particularly if they've got an avoidant negotiation style, will be reluctant to commit, will be frightened to do so. Having the lawyers there can often allow them to get over that barrier. It can definitely assist with the reality testing, particularly the reality of what's likely to happen if they did end up going to court in whatever jurisdiction it is that you're working in. And it's very helpful when discussing the worst alternative to a negotiated agreement, to the proposals that are on the table, and the most likely alternative to the negotiated agreement. So they're all really good positives of having legal representatives there in the room. Some of the potential negatives that sometimes they can try to take over the process and sideline the mediator. So that if we've got lawyers that are quite aggressive in their approach, that can be a little bit of a power tussle with the mediator themselves. They can try and speak for the client and advocate their position, sidelining the client. And unless you're doing a process where that is what happens and is expected, in most cases, they're there to support the client rather than to speak for the client. This is often spoken about. Certainly it's a problem that's identified in a group I run. They can seek to undermine the mediation process for their own interests. I would say that it's rare that they're deliberately sabotaging the mediation in order to continue the court case, which is more financially rewarding for them, but it's certainly something that's spoken about. It would be, I hope, a rare occurrence. And there can be a lack of understanding of interest-based negotiation. And so there pushing too hard to try and get that compromise right off the bat, or for their clients' interests, and totally disregarding the reality that someone's not going to agree to something in mediation if it's just a lose for them. Any other thoughts on this? Any other positives? That last point I made about how sometimes the lawyers are pushing for that win-lose process. And look, it really relates to different styles of negotiation. As mediators, we're trying to generally facilitate an interest-based negotiation. We help our clients identify issues, clarify facts, find their interests, develop options, consider needs, develop some way of rating those options and proposals, and eventually reaching an agreement. Whereas in a positional bargaining, it starts the same, identifying the issues, clarifying the facts. Then it usually goes to developing positions, advocating for those positions. Usually there's a compromise happening, reducing demands, considering offers, and then at some point there'll be a settlement agreement. So lawyers that are really used to negotiating in that positional bargaining, and it can happen in a number of different contexts, industrial relations, it's very classic for that positional bargaining to happen. They may not understand what we're trying to do with mediation. They may find it's too interest-based negotiations, it's too soft. Why are you doing all this talking? Can't we just get to the deal? And so they may be getting frustrated with us, with our process, not understanding, what we're actually trying to achieve. So to get the most out of having the lawyers there, you may need to educate them as well as the clients about your approach. Sometimes lawyers may have adopted a more competing negotiation style. So just so that we're all on the same page, this classic conflict styles approach. So assertiveness in an advocate is seen as a positive quality. So very much focused on the needs of their client and disregarding, undermining or minimising the valid points of the other side, because that's where the focus is on. So if you've got a lawyer in the room who takes this approach, it can make it very difficult to have an effective mediation. I already talked about clients with avoiding approach. It can be quite useful to have the lawyer there to help clarify and build their confidence. And of course, we're trying to get everyone working together for a collaborative outcome that meets the needs and interests of both parties. I might just stop for a moment and check in. So the next thing, when we've got lawyers there or anyone else, or with the parties as well, building trust is the biggest challenge and the biggest benefit for us as mediators. I think that a lack of trust is one of the biggest barriers to agreements in mediation, and it certainly can be. Charles Green developed something called the trust equation, which he said is credibility plus reliability plus intimacy divided by self-orientation. With intimacy as mediators, we can count that as empathy. So credibility, the words we speak and our expertise. So establishing our role as the mediator, our expertise to facilitate this process. So whatever our credentials are to be the mediator, and be very clear in what we're saying, which is exactly what you drew out there, Daniel, about our expectations. And then reliability, so our actions and how dependable we are, consistently doing what we say we'll do. Building that reliability through enforcing our ground rules if we've felt the need to have articulated ground rules, or just enforcing respectful behaviour, which should be a minimum expectation that any mediator has. And then intimacy in this context is really talking about the safety and security we feel to share personal information with someone. We know that if we don't trust people, we're not going to share that. If they don't feel like they can trust you as the mediator, they won't share what their legal advice is, or they won't share what their interests are and things like that. So we build that sense of intimacy, that trust, that safety and security, using empathy, demonstrating we understand their situation and that sort of thing. And then that self-orientation. So if people are focused on themselves at the expense of others, it just decreases trustworthiness. So you can have all of those other things, but if they're not willing to consider the needs of the others, then it's for nothing. I'm not sure if I think that makes sense, but I guess it's an element of what we're working on when we have these other people as part of our process, because it is affecting the dynamic. And further to that, so some of the strategies we can use to build that credibility is, again, our agreement to mediate. So use your agreement to mediate, get the others to sign and confirm their roles, whether you get them to do the full agreement or you have an appendix on the back that has the additional information, additional roles. Include a section on the role of the lawyer, what the role is and what it isn't. They just provide support to their client, provide advice if asked. Generally, it wouldn't be to speak for them or act as an advocate. I'm aware that some of you might be in context where that is the role. If it is, what information do you have about self-determination in that process? Ultimately, the lawyer is working as an advocate for the client, and it's the client who is the person that has to live with whatever is agreed. So they still, in whatever type of mediation, still should be the final decision maker about whether an agreement is acceptable or not. So maybe just use the chat if you want to share whether you are in a context where the lawyer would be speaking for your client. I do family dispute resolution predominantly, and there wouldn't be a situation where I would have the lawyer speaking for their client, but I may allow them to speak and provide some advice as needed, not just in the individual sessions, but in joint as well. But I wouldn't force them, obviously. So they may want to just go to a breakout to provide that advice to their client. Some lawyers that are used to doing collaborative law as well, they may be more comfortable with that, and others just wouldn't feel that way. Pre-mediation discussion. So I know sometimes the lawyers want to be part of the pre-mediation discussions with clients, sometimes they don't. If you're in a court-ordered process, it may be that you don't actually get the chance to have a proper pre-mediation intake. In that case, you're really working with limited access. So you might need to have some documents and information guides that work for you. Yeah, Carol, as a lawyer, encourage my client to speak directly with the mediators. How sometimes I feel the need to clarify what they've said if the mediator hasn't really understood them or hasn't really heard them. Yeah, absolutely. Working in that way can be really powerful. So the lawyer steps back and then steps in as they need to. For some of us, like we know the lawyers we're working with, we've got that trust I just talked about built up. We don't need to do a lot of preparation. If it's someone who's totally unknown, then you need to think about how that's going to work, answering any questions, clarifying roles, checking their understanding of your process. They may be used to a different process. You, as the mediator, have, as long as you've communicated it and it's been agreed, you have the right to run the process as appropriate within your obligations and standards. The professionals only meeting. So some people, like Fiona Kirkman, she has in her process a POM meeting. So professionals only meeting, it's a paid meeting that they attend, and that in family law mediation is all around the preparation and making sure that everything's ready for the mediation to proceed. Because we work with information, particularly in the property setting, and it really can't proceed unless the homework's been done properly. So that's an option that may be needed in your process or may not be relevant. Of course, the lawyers often are more able to provide the necessary information, family violence orders, previous court orders, or parenting plans. In my context, any work that they've done on those initial negotiations, if that's relevant to your context. Some mediators, we just start with a blank page. We don't have any of that. But if you're in a civil or commercial mediation, there's going to be papers, there's going to be information. Same thing if it's court ordered. So again, context. Just mindful of time. Please do interrupt if you've got any questions or comments coming through. In our opening statements, again, it's an opportunity for us to remind everyone of their role, remind the lawyers or the other support people not to be tools. And you want to make sure you're adjusting your opening statements so that you're just quickly confirming those roles. What do you want them to do? Support their client with legal advice and prompts as needed, assist with reality testing of proposals and negotiation, encourage their client to request a break when needed, but generally not to speak for their client, and definitely not to be adversarial and combative. So you might think about how you communicate that. In the exploration and discussion stage, again, where possible, we're trying to get the parties to speak directly. They may provide advice in the room, like in collaborative law, or need to go to breakout sessions, depending on their approach. In the option generation, they may be assisting. So is it SWC? Will it solve the problem? Is it workable? Are the parties committed? See if that's going to work. And again, that impatience that you can sometimes have with the lawyers, reminding that we don't need to push too early for options, but that it's okay to explore the various options. We don't have to push for a decision. Negotiating proposals, again, we're shifting from talking about options to talking about proposals. Sometimes you need to help with reframing the language. So sometimes some of your advocates may be very adversarial in the way that they speak about things. We're wanting to reframe things to proposal. Okay, so that's the proposal. Do you need any clarification about the proposal that's just been put? Any questions? Maybe you ask some questions yourself. So just diffuse that a little bit so that it's clear that people still have the power to say yes, or they can be very helpful in getting greater clarity around the options. Generally, the lawyers will be busy noting things down, which can be helpful, but you want to make sure you're taking your own notes as well. And depending on, on your style, you might be starting to taper into allowing, more involvement in the discussion as you're starting to get down to the nitty-gritty. But again, everything's got to go back to the client. Sometimes if you're finding that the lawyers are being difficult to manage, you might have sometimes I'll call for a professionals only little gather and have a little chat with them to calm things down if necessary, or go to breakout rooms. Whatever stage in the process, you can manage who's in the room to manage the process. That makes sense, hopefully. Agreements and next steps, again, being very clear about who and how, who will write up the agreements, how they'll be written up, and making sure that everyone knows that agreement writing is about clarifying what's been agreed rather than starting new options or new issues. We're watching the time to make sure that it's manageable and we can get things finished rather than having too much half done. Sometimes it's necessary just to remind the lawyers, particularly if one of the lawyers is writing up, that would be a breach of trust to change anything that's been agreed, like adding in new different clauses that haven't been discussed in the mediation. So if you've got doubts about that, making sure that everyone understands that the expectation is that it will be that they'll be documenting what was agreed, not using the power of the pen to add in new bits and pieces. That's another problem point that sometimes can happen in mediation or after the agreement is reached in mediation. Just for those who are doing family law mediation, the certificate of dispute resolution, there we generally, when you've got lawyers involved, the agreement's going to be taken away, drafted up and then signed. So we can't actually fill out the certificate to say whether all of the matters have been resolved until we know whether or not that's been done. So we need to have that feedback loop if we do need to issue the certificate of dispute resolution. So this is family court ordered mediation, which is not relevant to it. So just as a recap, key points: you own the room. Educate your guests about your process and your ground rules. So don't be worried about doing that as a mediator. You're doing the best service you can for your clients by doing that. Ideally, if you can, in advance of the mediation day, so the expectations for the day are very clear. Get everyone to sign your agreement to mediate with their roles clarified, an annex, whatever it is you need to have so that you're satisfied. And then you must enforce your rules. If you want to relax them later, that's okay, but announce the change. So it might be when you're getting into that negotiation that you say, okay, I'd like to invite you to maybe be a little bit more involved now as we're going through the detail of what's been agreed by the parties, rather than just turning a blind eye, if that makes sense. And we're really wanting to enlist the lawyers as allies in our process of finding a resolution. It works for the family or the individuals or the companies or whoever it is that you're working with. Excellent. So hopefully that has been helpful. If anyone's got any last comments or thoughts before we go, next week it's group supervision. So group supervision is never recorded and you have to attend live, and daylight saving, so it's 12 to 1 now in Queensland, and what are we in 10 in. And the other thing for anyone who's a member, we've done an update on the maps for anyone that we believe wants to have a public profile, and we're building panels on some other software. So there's a page on the MI members website to go and check if you're on there, whether you want to be on there or you don't want to be on there.
I'll put it in the chat.
Oh, thanks, Ro. And there's a form there if any of the information needs to be updated, just letting everyone know about that. Excellent.